Hello everyone, welcome back to our channel Law Point. This is Renu Thomas, your host for this episode. Our previous sessions were on mortgages. Today we'll be dealing with the frequently asked questions on this topic. We have with us Supreme Court Advocate on record, Mrs. Priscilla Elizabeth Joseph, to answer our queries. Is it possible to have a mortgage in favor of movable property? And if so, what are the legal implications?
Mortgage of a movable property is called pledge or hypothecation. If you pawn your gold jewelry at a pawn shop or a bank for a gold loan, then this process is called pledge. Here, this is not called a mortgage because mortgage is relating to an immovable property, whereas pledge is with respect to a movable property. Here it is gold jewelry. Here, the owner of the gold jewelry takes the loan and he takes the money, and the possession of the gold jewelry is with the lender until the loan is repaid by the borrower. In this case, the gold jewelry becomes the security for the gold loan. We have seen that this arrangement is called pledge. However, under the Indian Contract Act, this arrangement is called bailment under section 172 of the Indian Contract Act. Now let's see, if you are taking a vehicle loan to buy a new car, then there will be a hypothecation agreement where the lender gives you the loan against the security of the car. The difference is that here the possession of the car is with you only, the borrower. However, a charge is created on the vehicle as a security for the vehicle loan. Section 2 Clause N of the SurfaceE Act deals with hypothecation in financial transactions.
Could you provide information in which a usufructuary mortgage can be legally pursued?
We have seen in our previous session that usufructuary mortgage is a mortgage where the possession of the mortgaged property is handed over to the lender, that is the mortgagee, by the mortgager borrower to use the property and receive rent profit from the property until the mortgage money is paid back by the borrower, that is the mortgager. We have also seen in our previous session that the limitation period covering each kind of mortgages if you are resorting to legal proceedings. There we have seen that if the mortgager wants to redeem or get back the mortgage property after paying the full loan amount, then he has to file a suit for redemption within 30 years. However, in case of usufructuary mortgage, even if it is 35 years or 40 years or 50 years, the mortgager, if he pays back full loan amount, then he is entitled to get back the mortgaged property from the mortgagee. So the mortgager, even after 40 years or 50 years, can file a suit for redemption of the mortgaged property if the mortgage entered into was usufructuary mortgage.
Can you elaborate on the concept of mortgage's right of redemption?
The mortgager's right of redemption is the legal right or legal entitlement of a mortgager, that is the borrower in a mortgage, to reclaim or recover the property back from the mortgagee after repaying the entire mortgage loan amount. For example, Mr. Smith took a loan from Mr. George by giving his farmland as security for the mortgage loan. After 3 years, Mr. Smith is in a position to pay back the loan amount. However, Mr. George refuses to give back the farmland back to Mr. Smith. Then Mr. Smith can file a suit for redemption before a civil court to get back his farmland from Mr. George. This mortgager's right of redemption is provided under section 60 of the Transfer of Property Act. This concept is based on a term, once a mortgage is always a mortgage. The mortgagee, that is Mr. George, cannot impose conditions on Mr. Smith for reclaiming back the property if that condition was not there when they entered into the mortgage agreement. We have seen that this mortgager's right of redemption can be availed by the mortgager within 30 years from the date this actual right arises. That is, that from the date Mr. George refuses to give back the mortgage property back to Mr. Smith, then within 30 years, Mr. Smith can file a suit for redemption. If Mr. Smith does not file a suit for 30 years, then Mr. Smith's right over the property extinguishes.
Could you explain the legal aspects surrounding a mortgager's right to foreclose on a property?
We have seen that suit for redemption is the legal right of a mortgager to get back his mortgaged property. Now, there is a suit for foreclosure. This is the legal right of a mortgagee not to give back the property back to the mortgager. Now, taking the same example, Mr. Smith took a loan from Mr. George and he gave his farmland as security for the mortgage loan for a period of 3 years. If Mr. Smith defaults in paying the monthly installments or even after 3 years is not in a position to pay back the mortgage loan amount, if Mr. Smith has not filed a case for suit for redemption of the mortgage property, Mr. George can file a suit for foreclosure, foreclosing the right of Mr. Smith from reclaiming back the property from Mr. George. In other words, the suit for foreclosure is the right of mortgagee, that is Mr. George, to declare that Mr. Smith is absolutely debarred from exercising his right of filing the suit for redemption in the mortgaged property.
Thank you for watching. See you next week with another legal topic. Till then, bye bye.